Hey guys, today we're going to discuss the preparation of a court document called the Schedule of Assets. Now, when I prepare wills for my own clients, I always tell them to write down a list of all their assets on a piece of paper and attach this piece of paper to the will with a paper clip, of course. And whenever they acquire a new asset, for example, they open a new bank account, a new fixed deposit, a new whatever, a new brokerage account, or purchase a new property, all they need to do is just write this down in their list of assets so that when they die, their executor knows exactly what assets you have after you die because it's clipped together with the will. As you should be aware, after you die, your executor has to obtain this thing called a grant of probate before the banks, the insurance companies, the CDP, the brokerage companies, HDB, SLA, before they will release monies or allow the sale or transfer of property. You can watch my other video. So, writing this list of assets before your death will make it easier for your personal representative to identify the assets that you own and to ascertain how much they are worth after your death. As an aside, personal representative is a general term that is used for both administrators. Administrators are persons who administer the estate if a person died without a will, and you get a grant of letters of administration. If a person dies with a will, the personal representative is the executor. So since the Schedule of Assets is applicable to both letters of administration and for grant of probate, they are the same document, Schedule of Assets. Okay, I will use the word personal representative to refer to either an executor or an administrator. Without a list of assets, it will take the probate lawyer a long time to write to the institutions such as banks, insurance, CDP to obtain information on whether you had an account or policy with them. That's why you should periodically review your list of assets that you attach to the will so that you make sure it's up to date as possible so that your personal representative will not have to go to the trouble of confirming your assets after you die. This is because the probate lawyer will have to prepare a court document called the Schedule of Assets. The court document is called Schedule of Assets. The thing that you write down and you attach to the will, I just call it a list of assets. That's an informal term, list of assets. But the court document is called the Schedule of Assets, okay? So the probate lawyer has to prepare a court document called the Schedule of Assets, which essentially lists out all your assets, including your properties, bank account, fixed deposit, securities trading account, CDP account, your motor vehicles, insurance policies, overseas assets as well, and mortgage debts. The Schedule of Assets will need to state the account number, the account or policy number, and the estimated market value. You do not need to include your CPF money in the Schedule of Assets. If you wish to distribute your CPF savings to others, you should instead make a CPF nomination. Otherwise, your CPF will be distributed under the rules of the Interstate Succession Act, which means people who die without a will. The court document called the Schedule of Assets can be found in Form 226 of the Family Justice Practice Directions. It essentially requires you to structure your assets under three main categories: local property, outstanding local debts that are secured by mortgage, and overseas property. In addition to updating the list of assets that you clip to your will, you should also update your will in order to remove outdated instructions on how your assets should be distributed, or to add in new instructions on how new assets should be distributed. If you have updated your will and list of assets, you should always inform your personal representative of the changes so that he or she can file your most recent will and most recent schedule of assets with the court when applying for a grant of probate or a grant of letters of administration after your death.